Right, well, after some delay, thank you very much for your patience. I welcome members to the 13th meeting in 2014 of the Delegated Powers and Law Reform Committee, and I ask members to switch off mobile phones. Can I say I'm actually hearing some feedback which suggests something might be a fraction too loud. Let's see how that goes. Thank you. Right, after asking members to turn off mobile phones so we don't get any more electronics, agenda item 1 is a decision on taking business in private. It's proposed the committee takes items 6, 7, 8 and 9 in private. Item 6 allows us to consider further the delegated powers provisions in the Historic Environment Scotland Bill. Item 7 is consideration of the committee's draft report on the Courts Reform Scotland Bill. Item 8 is to allow us to consider whether we wish to provide additional information to the Standards, Procedures and Public Appointments Committee as part of its inquiry into the procedures for considering legislation. And finally, item 9 is consideration of the evidence we are about to take on the Food Scotland Bill. Does the committee agree to take items 6 to 9 in private, please? Thank you. Which brings us to agenda item 2, which is the Food Scotland Bill. This is an opportunity for members to ask questions of the Scottish Government officials on the Food Scotland Bill, and I welcome, after some delay, from the Scottish Government, Maurice Fraser, who's the Bill team leader, and Lindsay Anderson, solicitor. Thank you very much for being here and again for your patience. And I know we have some questions for you, and providing I can find them in the right order, I'll be able to suggest who's going to start. Thank you, John.
Thank you very much, Chairman. Good morning. Could I ask you about Section 34 of the Bill, which allows provision to be made for the purpose of regulating animal feeding stuffs, which applies to any provision in the Food Safety Act 1990, either with or without modifications, or which is equivalent to any of the provisions in the 1990 Act. Can you explain, please, why it's necessary for this power to be drawn in such wide terms?
Yes, thank you. I suppose the first thing to say about Section 34 is that it's not actually a new power. It's a rewriting of a power which exists currently in Section 30 of the Food Standards Act 1999. So it's actually a power which is available currently to ministers. Now, when the bill was being drafted, I suppose there was a decision to be taken about whether we should just amend what was in the 1999 Act, which we could have done by consequential amendment, mainly because it requires consultation with currently the FSA. And instead, what we decided to do, rather than leave the power, I think draftsmen talk about orphan powers left in an act that was no longer going to be of much relevance once the bill passes through Parliament. We decided to replace it with a new power in the existing bill. So Section 34 reflects a power which actually is, and I appreciate you don't have it in front of you, but in the 1999 Act it's drawn in similar terms, almost identical terms, including the ability of ministers to make provision or to use provisions from the 1990 Act in regulations which they make under Section 34. And it was just decided that it was more convenient to have it in an Act which is dealing with the new food body and the new powers that Scottish ministers are being given, rather than leaving it abandoned, as it were, in the 1999 Act. So, in terms of the width isn't new. It's reflecting what Scottish ministers already have power to do.
Are in different times from where we were in 1999, of course, with BSE, and very much an interest in animal feedstuffs at that time, and therefore not certain why we still need perhaps such wide powers, but I hear what you say. Anyway, my next question is that the powers in Section 34 could be used to apply offence provisions under the 1990 Act for the purpose of regulating animal feeding stuffs. That being the case, would you agree that the power to modify the provisions in the 1990 Act, which are applied for that purpose, could be exercised so as to alter or remove any restrictions or limitations on the penalties for those offences which the 1990 Act may otherwise impose?
Do you want me to?
Yes.
Again, that's it's not actually that unusual. I know that this committee will spend quite a lot of its time considering food statutory instruments. I know you'll see a lot of those. And the 1990 Act, excuse me, the Food Safety Act of 1990 provides a lot of the enabling powers for implementing European obligations. Sections 16, 17, and I think it's 48 as well, are the main powers that are used in that context. And those powers, similar to Section 30 of the Food Standards Act, which we're here reenacting in Section 34, have a similar provision, this ability to apply the 1990 Act provisions and then to the terms of the regulations and to adapt them to the terms of the regulations. And that's really all that power reflects. I think you do actually find it elsewhere in the bill, but it's quite a common device, and it, I suppose, purely from a technical point of view, my point of view, I suppose, is that it's very consistent with the Food Safety Act and with a sort of well understood body of law, including the many SSIs that are made every year under the Food Safety Act. So, again, I mean, and from a point of view of how of policy, that's probably more Maurice's area than mine. But it's not, I suppose, it's not an unusual device in food legislation, and it's I suppose well understood by the readers of food legislation, users of food legislation.
So I take it that you would agree then with the question, and if so, can you explain then, please, why it's appropriate to take a power in subordinate legislation which could be used to apply offences with unrestricted penalties, as we understand it?
I think it comes back to Lindsay's point of consistency, that can be done already across the 1990 Act. So it's not introducing anything novel in that sense. So it's just making it consistent with what already exists.
Okay, thanks very much.
So if I may just follow from that, then, if unrestricted penalties concern us, which in principle they always do, we should be addressing that question to the Policy Committee to consider why it is they're happy to take the 1990 policy into the new Act. Yeah. Thank you very much. Margaret.
It seems the effect of the exercise of the powers under either Section 36(3) or Section 42(4) to prescribe additional information to be included in either a fixed penalty notice or a compliance notice, respectively, will be that the information to be included in either type of notice will be contained in two separate places: the bill and any subordinate legislation that is made in exercise of these powers. Can you explain why it was not considered to be clearer to take a power to modify sections 36(1) and 42(1) so that the information to be included in either a fixed penalty notice or a compliance notice is contained in the same place, please?
I think it's technically true to say, yes, it could be in two places, but it's only one list. There's some which are must-haves, if you like, which are going to be there, and they're on the face of the bill. But to allow fixed penalty notices and administrative sanctions, for instance, and other sanctions to work together, that there may be other things that are done and brought in, and this allows us to have a little bit more flexibility than just putting everything on the face of the bill. I think, frankly, we wouldn't want to be too restrictive by only saying what has to be in the fixed penalty on the face of the bill. When this was consulted on, in fact, it was envisaged that Food Standards Agency consulted on this, and they envisaged that this would be just a blanket power to just have these new sanctions. So we've actually taken the approach that we want to put as much detail on the face of the bill as we can, hence the two places, if you like, that we're trying to put on a list of the must-haves, but we don't want to be too prescriptive and not allow to future-proof, I guess, to not allow things that happen in the future to be missed out.
And again, could you suggest, pardon me, anything that you think you might need to add to it? Because there's an element of future-proofing that simply says, well, if we ever do, it would be sensible to have the power, which I think we would understand. And others would say, well, I can see this list coming, so we'll prepare for it. I guess we'd prefer you to see that list coming and prepare for it in a different way.
Absolutely. I think we would probably have things suggested to us in consultation when we're if we were doing something by order and bring something forward, people will have a chance to comment on that. I can't off the top of my head think of an example. I could probably go away and think about it and send something back to you, but I can't off the top of my head think of, wouldn't like to commit to a specific at the moment.
No, I mean, I think the point of the section is simply to, believe it or not, to be helpful. And in setting up a new system, I suppose the Scottish Government's conscious that this administrative sanction system is quite new. Well, it's very new. There's nothing similar in food law at the moment, although there are obviously administrative sanction systems in other areas. So it's really to give the system room to develop. And if the most likely scenario would be where over time it becomes apparent that additional information would be useful to recipients. That's probably the main motivation, and just the fact that the novelty of this system within the area. I think that's probably as I say, it's supposed to be a helpful a helpful provision.
Well, certainly I understand that. That makes perfectly good sense. Has any thought been given to the idea that once, for any reason, a list is modified, that the whole list should then be reproduced in this other modification place in such a way that somebody seeking the law only has to go to one place? Because I think that's the fundamental point that we would like to see.
In administrative terms, the list would be held on a website. I know it's not the same as being in the bill, but as time goes on, people tend to less and less use the original bill as a definitive list, knowing that there's normally, in the run of course of things, the amendments can be made. So the Food Standards Scotland will have on its website, apart from anything else, and the Scottish Government will no doubt make sure that happens. So there will be a one place to go, if that would answer the question.
I think it does make the point that maybe, whilst lawyers go back to the original materials, you're far more likely, if you've got to fill in a form, you go to the form where you find it. Yes, thank you. Right, I think that takes us to Stuart, please.
Thank you very much, Convener. Looking at section 60 of the bill, which provides that any supplementary, incidental or consequential, that's the first part, and then any transitional, transitory or saving provisions may be made, and that is the 6 headings with which we're familiar. Why is section 48(1) needed?
In policy terms, section 60 is very broad. Section 48 is much more specific. It has a very similar effect. I would argue that section 48 is a more targeted, more specific order-making power, which we put at 48 just to help the reader understand that as they're reading this, there is always this power for it to be changed, but anything else. So if we were only to have it, if we wanted to be as helpful as we are in 48 in section 60, section 60 would have had to be very long, rather than just having those 6 headings you're used to in the 2 categories. We would want to be as helpful as we can at 48, in other words, and so by being helpful, that helpful there helps the reader. It's right beside the rest of section 48. If we'd instead put that in section 60, it would have made 60 particularly very long.
I'm actually much more fundamentally puzzled as to why it's needed to be in the Act at all. I can understand why one might put what is essentially in 48 into the Delegated Powers Memorandum, because it touches on the exercise of delegated powers so that it is available for people to read. But it is actually, it seems to me, adding, and I make a very slight caveat in that subsection 4, it essentially gives some definitions which may add, but it only does so in the context of the powers that 48 isn't adding a single power to this Act in any way, shape or form, because they're already in 60. Or am I misunderstanding in my non-legal, simple-minded view?
Lindsay might have a view on the legal aspect, that certainly the policy aspect, that there is a... my reading of it is 48 actually goes potentially further. It does add, even if it is only small, it does add...
Well, could you help us understand what it adds, and then we can see whether it should be there? Because 60 as it's cast, it seems difficult to work out what's not included in 60. I'm not seeking to rebut the point that there is helpful in terms of explanation, but I'm wondering whether it's necessary to put it in the bill for readers to have access to that information.
Well, I think there are some differences between 48 and 60. 60 is broader in the sense that it allows for greater amendment of primary legislation, including the bill, as is quite often the case with ancillary provision. That's more limited in section 48. Because what you're able to alter only are the provisions.
What I think would be helpful is if you could point to any aspect of 48 that is not created as a power by the quite modest and quite standard section 60.
I think 48 is there to avoid having a debate about the width of section 60, and again, it's probably there to be helpful. Again, and this idea of having all the relevant provisions in one part, I can see that.
Would it be just as helpful if what's essentially in 48 were in the Delegated Powers Memorandum as an illustration and explanation of what might be done with the powers that are in section 60?
I think that would be fair to say.
Right. Okay. Well, that's sufficient for our purposes for the moment. Because we are not trying to examine the policy. That's not our role as a committee. So I don't want to. And the convener would surely pull me up if I did stray into policy matters. Right. Okay. Now turning to what is in 48, because it is in the bill. Albeit what you've just said might suggest the government could think whether 48 is needed, but that's for another day in another place. Looking at section 48(2)(a), which relates to fixed penalty notices, compliance notices, other administrative sanctions, can you perhaps just flesh out the relationship that exists between these various administrative sanctions so that we can better see how the secondary legislation aspect of this interacts?
Okay. It's better to start with the compliance notice. Compliance notice is a useful tool for an authorised officer who perhaps notices something or sees something minor, which is technically an offence, which at the moment the only sanction they would be able to offer would be to prosecute, and it might be just totally disproportionate to prosecute. So the idea, as with improvement notices from the 1990 Act for food safety purposes, the idea is to introduce something slightly more useful and practical. In other words, here's a notice saying you must make an improvement to this or face a penalty. So we think that's an entirely proportionate approach to take to minor offences.
It also gives legal force to something they could do informally anyway.
Yes, absolutely. Yes. Absolutely, yes. As at the moment you can either informally have a word with someone or go to court, and there's only probably about 15 prosecutions a year, and that would suggest that everyone is doing absolutely wonderful work, and there's never any breaches of any food safety or food hygiene regulations. I think it doesn't. I think it rather suggests that there is a lack of tools available to enforcement officers at local authority and within the Food Standards Agency at the moment. So that's what the compliance notice is aimed to do. It gives it slightly more force than just advice, and there is a penalty for not complying with it. The next step up, if you see it that way, is a fixed penalty. Something that isn't such a minor offence, or it's perhaps been an offence which has been committed several times, can attract prosecution. It would normally attract prosecution. The authorised officer and the food business could agree that it would be more appropriate to have a fixed penalty for that offence than to go through the prosecution. In which case, fixed penalty notice is issued, and after a certain time it's due for payment. Failure to pay is an offence as well. So that's two different levels, but because of very different circumstances, I suppose, could arise where somebody does 2 or 3 different things wrong. Some might be a fixed notice, some might be a compliance notice required, rather than one blanket. So there are 2 very definite, different, separate powers, but they might be issued simultaneously. They might be issued to the same business at the same time. So we have to have some way of organising how they fit together, and also how they fit together with the other type of enforcement activity, that other tools which are available, such as the improvement notices and the other ones listed in the Act here, in the bill. Sorry.
The section also talks about facilitating the issuing of further administrative sanctions. What does that mean? What would be an example of how that facilitation would come into play?
Well, exactly. The facilitation would be the ability through this to combine 2 different types of notice. So to be able to combine them and see how they react with each other requires some facilitation.
Is that a standard legal term? It's not one I've seen in other legislation. In other words, it says facilitating, prohibiting, or restricting. Is facilitating something that will be easy for the courts, if it comes to that, to interpret?
Well, it will be a legal term. Is it a standard?
I'm not sure I can think of another example off the top of my head.
So this has that dreaded thing in the civil service of being novel. Right. Finally, let me just look at section 48.4, which provides. Let me just see. Yeah, section 45. The ministers may modify all of this anyway, but I suppose it just seems to be quite unlimited. And in particular, you could modify the definitions, such as the definition of another sanction, which seems to be a quite improbably wide power. What again are the sort of things that would, by example, justify being able to change the definitions and really go quite to the heart of some of the things the Act's trying to do, it would seem?
It wouldn't be to create a new sanction. The power isn't to create a new sanction, it's just to describe another one. So the definition is... to your point. Okay.
It would just redefine it, but not create it.
Yes, none of 48.4 is created by 48.4. It's just listed there as having been created somewhere else. So that's why 48.4 is it just defines. It doesn't set. So 5 just gives that terrible future proofing again, that if something is enacted as being an offence, to have it applicable here along with the other ones as part of the toolkit of environmental health officers, we just have a definition in here of it. So it's not creating, it's a very wide power of definition.
Thank you, Camilla.
That's actually very helpful. I can't help just wondering, are there any precedents in Health and Safety Factories Acts kind of law for some of the things you're doing here? Maybe not a question you want to answer now, but if other people start asking you about the policy background, it might be that would help you.
Yes,
So
Kathy.
thought. Right, thank you, Stuart. That brings us to Mr McMillan, please.
Thank you, Convener. Good morning, panel. First question is regarding section 48, and certainly section 48(3) of the bill permits the modification of sections 37 and 44 of the bill by regulations made under section 48(1) for the purposes mentioned in the section 48(2), where ministers consider that necessary or expedient. Section 37 and 44 of the bill relate to the effect of a fixed penalty notice or a compliance notice on criminal proceedings. Can you explain to the committee how this power is intended to be exercised, in particular in what circumstances might it be necessary or expedient to modify sections 37 and 44?
Thank you. I think this goes back to what Maurice was talking about early on in relation to the regulation of the relationship between the different penalties that we're creating, and it's like there against the possibility that a fixed penalty notice and a compliance notice are issued at the same time. They both have the same effect on criminal liability, although that's discharged in different ways depending on the type of notice. And so the provision there in 48(3) is really just to help to regulate that, so that you don't have the discharge of criminal liability in both cases, but that you can regulate the way that the two notices act together to discharge liability. And it was really, again, just thought that it would make more sense if you were in a position where both a fixed penalty notice and a compliance notice were going to be issued, that you had one point at which liability was discharged within the observance of those two notices, rather than this what would otherwise be a slightly strange position that both notices discharge liability, but it wasn't obvious the effect that discharge with respect to one notice would have on your obligations under the other notice. So that's really why 48(3) is there.
So it was excuse me, it seemed to be more of a simplification procedure.
Yes, in an instance where it's decided that the notices can be served with respect to the same set of circumstances. So where you get the sort of layering of notices is to try and simplify the situation for the recipient of the notice, so that their position is clear and they know exactly what they have to do and what the effect of that will be on their liability.
Okay. Second question is regarding similar sections 37 and 44, but can you explain why it's appropriate to permit the modification of sections 37 and 44 using subordinate legislation? And bearing in mind that also sections 37 and 44 of the bill prohibit the bringing of criminal proceedings in circumstances where a fixed penalty notice or, as a case, maybe a compliance notice has been issued. And they also prevent conviction in cases where payment has been made under a fixed penalty notice or the terms of a compliance notice have been met.
I suppose it's really the same answer, that it's about regulating the relationship between the two notices, and that's what the provision's there for. It's not completely unheard of, obviously, to allow or to give a power to ministers to alter the terms of primary legislation through regulation. And I suppose to go back to the discussion we had earlier on about section 60. Section 60 is broader, and this is actually an example where section 48 is actually narrower, so it's allowing an amendment of the primary legislation only in very specific circumstances. And it was really thought appropriate, I think, because of the significance of what section 37 and 44 are dealing with, and the fact that they are dealing with liability, and so it's therefore necessary to make that very clear in situations where both types of notice are being used in one set of circumstances. If you've got anything to...
it's making it clear about how the liability and obligation are discharged in relation to the two. So it is about simplification.
Okay, thank you. Would you accept, though, that what we have on the face of the bill does, in principle, allow the government to alter the intention of 37 and 44 that something might be discharged, and that they could do that by subordinate legislation?
Right, it wouldn't be the intention, but
I'm not arguing that the government would want to do that, but this end of the table we worry about what they're being able to do.
I would turn to a lawyer at this point just to make sure I'm not committing us to say the wrong thing and promise something.
Oh, I suppose it's a lawyer's answer. It has to be necessary or expedient in connection with the operation of the Act. So, you know, it would have to be exercised in a way that was lawful and within the boundaries of the power. And as I say, the intention is really to regulate the issue of liability. But beyond that, yes, the policy wouldn't be for me, obviously, to comment on.
Yeah, thank you.
In the generality, it does appear that this bill is largely about taking many more powers. No? The broadening of powers? It feels like it. And if so, what's the justification for it?
Well, the broadening of powers is very much in reaction to horse meat and other things which have subsequently come to mind and come from the Scudamore Review, the expert advisory group that ministers set up. Also the Elliott Review for the UK, calling for a lot of broadening of the food safety and food hygiene in particular. So people are looking at ways to tackle food fraud, etc. This isn't specifically aimed at that, but the broadening of the power comes from that, but also comes from stakeholders. I mean, local authorities are very clear that they see this as a very welcome tool. So I would, although this is broadening up power, if you like, but it is offering a more practical, administrative, and then, you know, judicial, non-court, I should say, options to help food businesses and local authorities avoid very costly prosecutions and so on. So it's a widening of the available arsenal, but it is one that's welcomed by the stakeholders.
Yeah, thank you, John. I think we do have to be careful not to get into the policy issue, which will be considered. No, thank you. And that was helpful. But nonetheless, if we are setting up or we're looking at law which is widening, and I hesitate to use the word abused, but could be used in future by governments to do something which happens to be expedient, which is a historical word of some significance, you know, then that's why I think we as legislators should be asking ourselves, what's it really doing there? But I think we've heard what you had to say, and I don't think there's anything to add to it unless there's anything you would like to do so. Okay, thank you. In which case, I think that takes us to Mike Mackenzie, please.
Thank you, Convener. Both sections 43 and 45 of the bill contemplate the textual modification of primary legislation. Can you see why it is that you feel that the negative procedure is considered appropriate for that purpose?
Mainly because it's...
I think it was thought that Section 48 was actually relatively limited in that it applies as a specialist power for Part 3 of the bill in relation to regulations made under that part. And so to that extent, it's supplementary incidental powers, but only for very specific purposes. So it was thought appropriate that negative procedure was the one that we went with.
It's not a new. There's no offence being committed. No offence being created, and it really covers operational details and gives flexibility rather than being intended to be much more widely used.
Okay, I'm not absolutely certain that kind of satisfies me, but I think that's something we'll maybe think about further. It's intended that the guidance issued by the Lord Advocate under Section 51 of the bill will be published, or is it intended that it's published? And if so, why is it not considered necessary to include a requirement for the publication on the face of the bill?
That's really a matter for the Crown Office and the Lord Advocate to decide how they best make available and inform the public as to their, what they do. I don't know if it's worth explaining a bit about that. Is it?
Yeah, I mean, I think there's probably not a huge amount we can say. Obviously, it's a matter that will be for the Lord Advocate's discretion, and bearing in mind that it's in relation to an enforcement and an operational matter. I think whether or not guidance is published would be something the Crown Office would have to answer. The committee should probably ask Crown Office, I think, for an answer on that.
They don't. My understanding is I'm not an expert at all, is that the Lord Advocate guidance, when it's about enforcement and criminal proceedings and so on, isn't always published for fear of telling criminals what it is they can and can't do. That's not government policy answer here. That's just my understanding.
Yeah. Thank you then. Thank you.
Can I just challenge then, where do I find the boundary between something which is an enforcement and at the end criminal proceedings on one side, where I entirely understand your answer, and on the other side administrative processes which are designed to seek compliance, which is after all a lot of what this bill and others is about. Is there any guidance at all for us as to how far over you have to be before it becomes the Lord Advocate's bailiwick?
That's a matter for the Lord Advocate. The Lord Advocate, in giving guidance to and the Crown Office working, they make their own judgments on how far things can go one way or another. All we can do is set out what in the bill what we think are the right shape of things and the right level of penalties and so on, and then the Lord Advocate's guidance will help the courts decide. Are you asking actually whether somebody should give a fixed penalty, or a food business should take a fixed penalty when they know that the Lord Advocate's guidance suggests that the court has a lower penalty?
I'm not so much asking that specific question as asking whether there is a point in all these processes where it is purely administrative, and I'm trying to coin a legal term, and therefore the Lord Advocate isn't concerned. It is simply a process as administered by the local authority which says you do this, and if you don't do that, then we get to another level. Is there a legal line?
I think what might help is, again, going back to section 48(2)(c) and the application of provisions from the 1990 Act. You see an item, Roman numeral 9 there, section 40, part issue, codes of practice. We will be amending or making consequential amendments in the bill to the Food Safety Act 1990, and that's a power at the moment to issue codes of recommended practice, which obviously will sit separately to the Lord Advocate's guidance. So it may be in making these regulations under Section 48 that this power will be drawn down, but the power exists anyway in Section 40 to issue guidance to food authorities, so it's effectively local authorities in Scotland. So it may be that's also going to be relevant.
That's the food law, the code.
Yes.
Yeah. Yes. Sorry, I should have started with that. That there is, in fact, a code of practice published by the Food Standards Agency, which sets out what food law is and how food businesses must comply with it. But in that, it also sets out the relationship you're discussing. It sets out, where it sits in the administrative through to legal, so that is renewed regularly. And yes, using that power, as Lindsay said.
Super, thank you, Stu.
I just wondered if I could test an analogy and see if this helps us. I know that ACPOS, the Association of Chief Police Officers Scotland, has a number that relates to speed limits which is in excess of the legally required speed limit, where if a driver's speed is below that number, they simply won't prosecute. But that number is not published because, of course, it would simply become the speed limit. If, for the sake of argument, they decided not to, and clearly this is not the number, they decided not to prosecute someone who was doing 80 in a 60 zone, then everybody would drive at 80. And is it fair to say that in not publishing the Lord Advocate's advice in this respect and similar respects, it is similarly not a matter of good public policy to publish the flexibilities that are expected in practice from the system, and which could be changed at very short notice if that flexibility proved to be overly flexible? I mean, it's worth saying on speed limits in Australia, the flexibility is 0, for example, whereas in Scotland it is somewhat different, as I know from my previous experience. As Transport Minister, not as a driver, I should hasten to add.
Yes, and I think that's exactly the sort of scenario that we would have in mind. But as I say, it's really not it's not for the government to comment on that. But yeah.
Okay, thank you. I think that takes us to the end of our prepared thoughts. Do colleagues have anything else to ask? In which case, I think we've probably reached the end of that item. Can I thank you both very much again for your patience and for answering those questions so comprehensively. And I'll briefly suspend the meeting to give you half a chance to get away. Thank you. We can reconvene, please. Brings us to agenda item 3, which is instruments subject to affirmative procedure. No points have been raised by our legal advisors on the single-use carrier bag charge Scotland Regulations 2014 draft. Members have before them written submissions which the committee has received in relation to this instrument. Do members have any comments, please? No. Is the committee content with that instrument then? Thank you. Agenda item 4 is instruments subject to negative procedure. The Assigned Colleges Scotland Order 2014 SSI 2014-80. The meaning of the transitional provision in Article 3 could be clearer in respect that it would have been clearer to have referred to Schedule 2B to the Further and Higher Education Scotland Act 2005 rather than just Schedule 2B to the 2005 Act. In particular, it would have been clearer in this instance to have referred to the short title of the Act rather than abbreviating it, given that there is only one reference to the Act within the operative provisions of the order. Does the committee therefore agree to draw the order to the attention of the Parliament on the committee's reporting ground H, as the meaning of the transitional provision in Article 3 could be clearer? Thank you. Indeed. No points have been raised by our legal advisors on the Electronic Documents Scotland Regulations 2014, SSI 2014-83, nor on the Road Traffic Permitted Parking Area and Special Parking Area Argyll and Bute Council Designation Order 2014, SSI 2014-84, nor on the Parking Attendants Wearing of Uniforms Argyll and Bute Council Parking Area Regulations 2014, SSI 2014-85, nor on the Road Traffic Parking Adjudicators Argyll and Bute Council Regulations 2014, SSI 2014-86, nor on the Glasgow Commonwealth Games Act 2008, Duration of Urgent Traffic Regulations Measures Order 2014, SSI 2014-92, nor on the Right to Interpretation and Translation in Criminal Proceedings Scotland Regulations 2014, SSI 2014-95. Is the committee content with these instruments, please? Thank you. Agenda item 5 is instruments not subject to any parliamentary procedure. The Act of Sederent Fitness for Judicial Office Tribunal Rules 2014, SSI 2014-99. Our legal advisers have raised a number of points in relation to this instrument. Firstly, it is defectively drafted in the following respects. In Rule 2, presenting officer is defined as the person appointed under Rule 9.1, where the correct reference should be Rule 8.1. In Rule 2, investigating officer is defined as the person appointed under Rule 5.1, when the correct reference should be Rule 4.1. And Rules 8.1 and 8.6 refer to the presiding officer, where the correct references should be to the presenting officer. Does the committee therefore agree to draw the instrument to the Parliament's attention under reporting ground I, as the drafting is defective? A further point has been raised by our legal advisers in relation to this instrument. The meaning of Rule 6.2a could be clearer. Rule 6.2a2 refers to the date on which the tribunal notifies the judicial office holder that it has determined an application under Rule 5.1. Under Rule 5.4, where the tribunal refuses an application under Rule 5.1, it must notify the judicial office holder of that decision. There is, however, no provision for the tribunal to notify the judicial office holder in the circumstances where it is granted an application under Rule 5.1. It is accordingly not clear what the relevant date for the purposes of Rule 6.2a2 is in the circumstances where the tribunal has made a determination to grant an application under Rule 5.1. Does the committee therefore agree to draw the instrument to the Parliament's attention under reporting ground H, as the meaning of Rule 6.2a could be clearer? Thank you. The committee may, however, wish to note that the Lord President's private office has laid a corrective instrument which rectifies the drafting errors and clarifies the meaning of Rule 6.2a. The corrective instrument, which is also before the committee today, revokes the present instrument prior to its coming into force. Does the committee agree to note all this? We do. Thank you. No points have been raised by our legal advisers on Post-16 Education Scotland Act 2013, Commencement Number 4, and Transitory Provisions Order 2014, SSI 2014-79, nor on the Scottish Independence Referendum, Chief Counting Officer and Counting Officer Charges and Expenses Order 2014, SSI 2014-101, nor on the above-mentioned Act of Sederent Fitness for Judicial Office Tribunal Rules Number 2, 2014, SSI 2014-102. And the committee moves to note that that does actually correct the previous one discussed. All right. Is the committee content with all these instruments, please? Thank you. At which point we come to item 6, and I move the meeting into private. Thank you very much.